Hello everyone and welcome to our channel. My name is Anda Malescu and I am the owner of Malescu Law. We are a law firm based in Miami, Florida, and we specialize in the area of business and immigration, serving local companies but also international companies that do business in the United States. Before we get started, I want to say that we are open during the COVID-19 pandemic and we continue to assist our clients. If you need to contact us, you have the information here in the video. Today we are going to discuss the U.S. tax implication for those of you who are currently in the United States on a U.S. visa, especially a B1, B2 visa or a visa waiver program, and who may be forced to stay longer than expected because of the COVID-19 pandemic and the restrictions on travel. As a general rule, in the United States, an individual who is not a U.S. citizen or a green card holder can be considered a U.S. tax resident if the person has been physically present in the United States for 183 days or more during a calendar year. This means that if you are present in the United States in 2020 for 183 days or more, you are a U.S. tax resident. As a U.S. tax resident, you are subject to U.S. federal income tax on your worldwide income. This means that U.S. federal tax applies to any income that you derive anywhere in the world, whether it's from investment, wages, sales, any source of income would be applied U.S. federal income tax. Now, outside of these 183 days calculated in a calendar year, there's also another formula, a 3-year lookback formula to calculate the number of days present in the United States, which can also subject you to federal income tax. The 183 days can be calculated based on the current number of days you are in the United States in 2020, plus a third of the number of days you have spent in the United States in 2019, plus a sixth of the days you have spent in the United States during 2018. If based on this formula, the days cumulate to 183, then you are considered a U.S. tax resident. But under this formula, generally, you will need to average about 121 days in the United States for the past 3 years in order to be a U.S. tax resident. Now, there are exceptions to being a U.S. tax resident, and you may be able to qualify. There are 3 exceptions. One of them is based on your home country and the tax treaty that your home country has with the United States. Generally, if your country has a tax treaty with the United States, under a tiebreaker rule, you will be able to file documents with the U.S. Internal Revenue Services and be exempt from filing taxes in the United States. Another exception for those individuals where your home country does not have a tax treaty with the United States is the closer connection exception. For that, again, you will need to file applications with U.S. Internal Revenue Services to prove that you're closer, you have a closer connection with another country, and in that case you would be exempt from U.S. federal tax. And a third exception is a medical exception, which means that if you cannot leave, if you're currently in the United States and you cannot leave the United States because of a medical condition, then you can be exempt from U.S. federal tax. Of course, if you fall ill with coronavirus, you will be subject to the medical exemption, but even for that exemption to apply, you will need to file application with the U.S. Internal Revenue Services. Because the topics are quite complex, if you need to contact us about anything we discussed in this video, you have our information here, and you can reach us by email or phone. That is all for today. We will cover other topics soon. Please subscribe to our channel, and I will see you soon. Thank you for watching. Bye.